Hi Akanksha, how are you? Good afternoon.
Good afternoon, sir. I'm fine.
Okay, so Akanksha, can you please introduce yourself?
Yes, sir. My name is Akanksha Singh. I have completed my law from National Law University, Ranchi in 2018. After 2018, I cleared DJS in 2019, but due to some issues and a particular writ that happened, my candidature was cancelled. So since then, I've been preparing for judicial services. And right now, I also do some freelancing work and I teach to underprivileged students.
Okay, okay. So, Akanksha, you said that you cleared DJS in 2019. So,
Yes,
why
sir.
was your candidature cancelled?
So my candidature was cancelled because there was this particular person, candidate, who was claiming reservation on the basis of mental disability, that is bipolar disorder. And I was the last person in the general list. And since it was horizontal reservation, so granting a seat to him would mean cancellation of my candidature. And the High Court and the Honorable Supreme Court ruled in his favor.
Okay. So, Akanksha, did you not appear or prepare for any other state judicial service examination?
So I did appear for Bihar and MP, but
Mhm.
both of them I could not qualify the mains examination.
Okay, okay. So, what can we make out of it? Your primary target is DJS and other states are just the supplementary ones, or you are targeted towards judiciary and you want to get selected in a judiciary no matter what?
So I am targeted towards judiciary, but the reason which I feel that Delhi is more suited is because the pattern of questions that come in Delhi and other states is slightly different, and I think I am better suited to tackle practical questions rather than questions wherein I have to. Do rote learning in the sense that I cannot mug up sections in a manner as good as I can deal with questions which are practical in nature. So I think that is why Delhi is better suited to my performance criteria.
Okay, so you are saying that you should be getting into Delhi Judicial Services because the syllabus suits your behavior, conduct, or is it because you want to be a part of the Delhi Judicial Services? Because right now, the way you are telling it, I feel like you are finding the syllabus easier and more convenient to your
No,
persona, and that is why.
I'll rephrase, sir. So, to what I meant was that why is this particular examination important to me? But as far as judicial services is concerned, the motivation remains the same. That I want to be a part of the justice delivery system mechanism, and I want to apply all this knowledge that I've gained all through these years in a practical manner, so as to be a part of this system at the grassroots level. So that particular end is served in any particular judicial services examination, I would
Okay,
say.
okay, okay. And you find yourself better suited for Delhi Judicial Services.
Yes.
Okay. Akanksha, any specific hobbies that you possess?
So I like reading novels.
Okay, you like reading novels. Any specific non-fiction or fiction novel that you like?
So I read A Thousand Splendid Suns by Khalid Hosseini, which I really liked. It's
Okay.
a, if I may explain something about it,
Yes,
it's a
please. Yes.
yes, sir. So it's a novel that deals with two Afghan women, and considering the recent crisis in Afghanistan, it's very appropriate and relevant because at that particular time when earlier Taliban was in power and how it had affected the rights of women, how this despotic patriarchy that was present there, and how the women fought against it. All that is said through the story of parallel story of two women and how they fought against it and how one of them sacrificed so that the other could build a better life out of it. So despite the entire depressing undertones of the novel, there is
Mhm.
a ray of hope that is presented, and I think it's a beautiful novel.
Okay. So have you read Kite Runner from Khalid Hosseini?
No, sir, I have not read it.
You must try it. It's a good novel because you
Yes, sir.
being a person into novels, do try it. When we look at such novels, or when we look at any of the literary work, what do you think is actually the criteria on the basis of which a particular author is actually driven towards writing the novels and generating money out of it? What is the idea behind an author's
I
mentality?
think it So I think it differs from author to author, but to be very broad about it, I think the author looks at the reader's perception of it, as well as how far the readers can relate to something that he's presenting and how easily can they relate to it. Also, how contextual is it in the particular scenario, and how far elements of reality can be inculcated into it.
As far as we are aware, intellectual property rights has been newly added as a subject in your syllabus, yes?
Yes, sir.
So what is the amount that an author gets when any of his books are published and sold by a publication? What is that amount called?
It's a royalty.
That is called royalty. And how
Yes.
is the amount of royalty decided? What is the calculation?
I don't know, so I'm not sure. I'm sorry.
Okay, okay, not a problem. What does your father do, Akanksha?
So my father is a Hindi officer in All India Radio.
He's a Hindi officer. So you never thought about going towards journalism and All India Radio and maybe television?
No, sir, I don't think I had any specific interest in that particular area, but the habit of reading, that is something that I think I have acquired from my father. He's an avid reader, and so am I. So
Okay, okay. So Akanksha, you haven't done your LLM yet.
no, sir, I have not.
Okay, so judiciary was the primary aim since the very beginning.
I'm sorry, sir, I could not hear you.
Judiciary was the primary aim from the very beginning.
Yes, sir. Yes, sir.
Okay.
Ever since I cleared LLB, after that, I have been devoted to judiciary. I did get enrolled in LLM in Patna University. However, on the very day of the final exams, I had my MP mains examination, so I had to make a choice. So I went for
Okay.
MP mains examination.
Okay, okay. Any specific subject of your inclination, Akanksha?
So criminal procedure.
Criminal procedure, CRPC. Okay. Can you tell me what exactly is the term, what does the term transit remand mean?
Yes, sir. So when a particular person is arrested in some district other than the district from where the arrest warrant has been issued, so in that case, he is brought before the nearest magistrate, and from there a transit remand is given, wherein the remand is for the period which is taken, which is required to take that person before the particular court from where warrant has been issued, so that he can get an order of bail from the concerned magistrate or concerned judge. So this is it is a remand in transit. That is, it gives the custody to the police in transit from one place to another.
Okay. And what is a transit bail?
So transit bail is when a person is allowed, in the same context, if a person is brought before a magistrate in a place where he has been arrested, and the magistrate thinks fit, he can grant bail to that person. But this is transit bail, that is only for the purpose that only for that particular period that is required for him to go and submit before the other court and seek a proper bail from that court.
Okay, okay. What are the offenses, if you could name a few, what are the offenses which have got a non-bailable nature?
Which have got a non-bailable nature.
Yes.
Yes, sir. So murder, rape, culpable homicide,
Okay.
kidnapping.
Okay. So let's say you are selected in the Delhi Judicial Services and you climb the stairs and you become a session judge and you reach at that level. So
Yes, sir.
let's say you get a case where there has been a case of rape. Now,
Yes, sir.
you know that there is a rape victim, there is prosecution, there is the other side. Will you be giving any anticipatory bail to a person who has been accused of rape?
So, if the person accused of rape is accused of the rape of a woman under 16 or under 12 years of age, I cannot grant anticipatory bail to that particular person because, as per Section 438 and the recent amendment that has been brought, it is not allowed. But apart from that, looking into the circumstances of the case and after giving the public prosecutor as well as the informant a notice, I can, and after hearing the parties concerned, I can grant the bail if considered to be okay in that particular case.
Okay. In the recent past, there has been a very debatable topic, or rather a debatable case that has been discussed. That is the Mehrauli murder case, relating to the scenario of Delhi, wherein a person had cut his uh, partner in 35,
Yes, sir.
36 odd pieces and then disposed
Yes.
of the body in a forest.
Yes, sir.
And the people have been claiming for his uh, his death penalty. What do you
Yes, sir.
think has to be the criteria to decide whether a person shall be sent to the gallows for giving a punishment of death penalty, or what do you think has to be the factors to determine the same?
I think death penalty is something that has to be awarded in the rarest of the rare cases, as expressed in Bachchan Singh case. But even while analyzing whether it is a rarest of the rare case, we have to take into account the mitigating circumstances as well as the aggravating circumstances that are present in the particular case. Even in a recent case, the Honorable Supreme Court, I'm sorry, I cannot remember the name of the case, sir. While analyzing the particular jurisprudence of death penalty, the Supreme Court itself stated that when the particular criminal code, the particular lower court has to call into at the time of pre-sentence hearing, has to call into all the materials that are relevant at that stage, has to make sure that all the mitigating circumstances are recorded and not in a like not just in a casual manner, but so as to ensure that every mitigating circumstance is actually in the record, so that the appellate courts, when they are actually looking into it, have a record of mitigating circumstance as well as the aggravating circumstance. Apart from that, the Supreme Court also said that there has to be a psychological evaluation as well as a psychiatric evaluation. So the report of psychological evaluation and the psychiatric evaluation both have to be included along with it, so that it can be assured that what was the mental condition of that particular person at the time of doing the offense as well as afterwards, since at times it may be the situation that the appeal comes before the High Court after a significant period of time or before the Supreme Court after a significant period of time. So they also said that another psychological evaluation has to be done in order to understand what has been his mental status in the jail for the time period that he was in the jail. So there's all these factors have cumulatively to be taken into consideration in order to decide whether death penalty should be awarded in a particular case or not.
Okay, okay. What are the rights of an arrested person, Akanksha?
Yes, sir. So the rights of an arrested person are, first of all, that arrested person has to be informed of the grounds of his arrest. Secondly, he has to be informed of his right to bail if it is a bailable offense. Thirdly, if he is arrested, he has to be brought before the concerned magistrate within 24 hours. Fourthly, he has a right to have his lawyer, if not throughout interrogation, but during interrogation. Also, he has to be presented before the concerned magistrate within 24 hours, and this is exclusive of the time that is taken for the journey to that particular magistrate's place.
Let's say
These are
a
the
person,
things you can remember as of now.
okay. So let's say a person has been arrested and he's brought before you, and you find that there are bruise marks on his face, his
Yes,
or
sir.
her face. What will you
Yes,
do?
sir. So first of all, if a person is brought before the court while seeking remand and the police is seeking remand, so the duty of the court is to ask from that particular person if he has suffered any abuse, if he has suffered any kind of harassment at the end of the police, and if I see that there is a visible mark of any abuse that is there, or if there is an allegation of abuse, I'll make sure that he's not sent into police custody, but rather into judicial custody. Also, I'll order medical examination of the accused to ascertain the nature of bruises, and I'll call for a report of the medical examination that was made at the time when he was arrested, in order to ascertain that these marks were present at the time when he was arrested or not.
So does the judicial custody has a specific time limit?
So the judicial custody has the same time limit, that is 60 days or 90 days under 167, depending on the kind of offense that has been committed.
Okay. Now, when you look at the matters relating to complaint, how do you decide whether a complaint is genuine or not?
So when in case of complaint, we don't have the leverage of having a police report at our hand. So the entire information comes from the complainant itself. That is why section 200 of CRPC says that first of all, we have to examine the complainant and, if possible, his witnesses, in order to ascertain whether a prima facie case is made out or not.
Okay.
Also, if we are not satisfied with it, under 202, we can postpone the issue of process and direct an investigation to be made, or cause an inquiry to be made in the circumstance.
Okay. Where do you get to see default FIR?
Default FIR.
Yes.
I'm not aware of it, so I'm sorry.
Okay. Okay. Now, what exactly is the difference between discharge and acquittal?
So discharge and acquittal are operative at two different stages of a criminal trial. Discharge is generally given at the stage where the charges have not been framed yet. And in that particular case, if the court thinks that there's no material to proceed against the accused, they discharge the accused. However, acquittal is after the entire case has been heard on merits. If the court thinks that there is no material on which the charge has been proved, then the court acquits that particular person. Also, the effect differs under section 300. That is, in case of acquittal, it comes under double jeopardy. However, the bar of double jeopardy does not operate in case of discharge.
Okay. Okay. When we understand the difference between bail and bond, what are a few differences, if you can quote, what are the differences between bail and bond?
So as far as I understand, when a person is released on his own bond, that is when he does not need to provide any surety in that particular case. However, in case of bail, it is necessary for him to provide surety as well as security. So that is the only difference I can make out as of now.
Okay. So once you become a judge,
Yes, sir.
will it be okay for you to grant, will it be okay for you to become a surety if an offender who's a known person or who's a family member, will you be becoming a surety for such kind of person who's your relative and wants you to be the surety?
Sir, I think there is no embargo to it as long as I'm not involved in that case in the capacity of a judge. As long as I'm not personally interested in the matter, as in I'm not presiding over the matter or I have no influence over the matter, I can be a surety. But if there is any possibility of me having any kind of influence in the matter, I should not be a surety in that case.
Okay. Let's say, Akanksha, after you become a magistrate and an offense has been committed in the area of your jurisdiction, you haven't been provided an occurrence report. What
Yes, sir.
step would you be taking about that?
So I think that I can call for an occurrence report from the particular police officer, or when the police officer comes before me with a case of remand, while seeking remand, I can call for occurrence report at that particular stage, or I can also. So that is it. I think that is all that comes to my mind right now.
Okay. Okay. Thank you so much, Akanksha. That was a good
Thank you.
interview. Thank you so much.
Thank you.